Thank you, members. This is the appointed time. We have a quorum. Invite the administration in, please. The attendance list is in front of you. I won't go through the list. And at the meeting on the 13th of October 2017, members have raised some issues, and the list of issues raised is set out in paper number CB record 2297/1718/01. The administration has given a reply, which is CB record 2297/1718/02. So may I invite Mr. Howard Chan, Deputy Secretary for Food and Health, to walk us through the paper. Madam Chair, in relation to the list of follow-up actions required for the administration, we have provided a response paper. And some members are concerned about the practicing guidelines for Chinese medicine traders. Under the framework, we provide practicing guidelines for Chinese medicine traders for their operations, and a breach of the guidelines would lead to disciplinary action. We have forwarded the practicing guidelines for members' reference. And members are also concerned about the regulatory standards for pesticide residues and heavy metal contents in Chinese herbal medicines in Hong Kong and the comparison with other jurisdictions. We have set out in rather great detail the relevant information in the paper. And we also further elaborate on the point raised by members. And also, in relation to health products, our regulatory standards, and how we should deal with breaches. And also, in relation to the manpower development for the regulation and development of Chinese medicines under the Department of Health and the Food and Health Bureau. And this is by and large what this paper is about, and I welcome questions from members. Any questions from members? Deputy Secretary. In previous meetings, we mentioned in fact, members raised issues, and also deputations attending the public hearing raised the same concerns. Because in our discussion, we're not only confining to the bill itself, but also on the development of Chinese medicine and the relevant regulatory standards. We think that time is right for a review, and they would like to take this opportunity to express their views for a comprehensive review. So, Deputy Secretary, after listening to them, I don't know whether there would be another occasion in which you would conduct a comprehensive consultation review, because I recalled at the last public hearing, the industry also expressed their views, and I'd like to know whether, on the basis of their views expressed, you are going to conduct a comprehensive review on the development of Chinese medicine. Thank you, Madam Chair. The development of Chinese medicines cover two areas. First, on the development of the industry, and also on the development of a Chinese medicine hospital and the relevant facilities in the future. These two are interrelated because the development of a Chinese medicine hospital would help promote development of the industry. We can follow up on these two issues through different channels. Through the hospital authority, we are conducting a second stage consultation, seeking views from stakeholders on the development of a Chinese medicine hospital. So in terms of the positioning and the development approach of the Chinese medicine industry, in fact, this month, the hospital authority have met with different stakeholders, and in the coming months, we're going to hold detailed discussions with them on the development of Chinese medicines. about the professional development of the Chinese medicine industry, we believe that this matter can be taken up by the Chinese Medicine Council of Hong Kong because the committee comprises representatives from the industry, and there are two committees, one being one for Chinese medical practitioners and the other for Chinese medicines. So as we review the development of the industry, I think that this would be a more suitable platform. Once a consensus is reached, if legislative amendment is necessary, the matter will be followed up on by the relevant committee. So we already have this committee, right? And also the working groups. But there are still a lot of views expressed by the industry. So how can we make sure that the needs and concerns raised by the industry will be addressed? Because the industry is concerned, after passage of the bill, whether there will be another opportunity for them to discuss their concerns. Well, because this legislative amendment is quite simple in nature, it is about a recall order. It may not be a suitable avenue for the industry to express their views, but we have set up a committee exactly for the purpose of allowing the industry to express their views. At the public hearing and on other occasions, we have heard the views expressed by the industry. I think that it is more appropriate for the Development Committee to discuss the relevant matters. We do note the industry's concerns, and we do find ways to address their concerns. Dr. Helena Wong, you've arrived, and we are now discussing the administration's response paper. I'll see if members have any views about the paper itself. Deputy Secretary, would you also give this undertaking? I know you have emphasized a number of times that the scope of the bill itself is quite narrow. We should focus on the recall order. But why is it that we are discussing other relevant matters apart from the recall order? We're concerned about these other issues as well. And that is why we'd like to urge the administration to comprehensively review the whole system and allow an opportunity for the industry to express their views. Right. Of course, there is a suitable platform, and the administration would also like to step up the development of Chinese medicines. And that is why at the subcommittee we have in fact briefed members on the restructuring. There will be a Chinese medicine division. We hope that we will continue to liaise with the industry, and that we can deal with and address the concerns of the industry in a systemic manner. Now we are now referring to CB bracket 2297/17 and 18 bracket 02, the administration's response. Any questions arising from the paper? If not, then we can start the class-by-class examination of the bill. No follow-up? All right. So we can begin the class-by-class scrutinies. Who would like to take us through, please? I'm going to invite Dr. Choi to go through the class-by-class scrutiny with you. But the government is going to move 3 amendments. When Dr. Choi comes to the relevant section, he will also brief you on our proposed amendments. Dr. Choi, thank you. Let's start with the amendment of the long title of CAP 549, Chinese Medicine Ordinance. It says an ordinance to provide for the regulation of activities or matters relating to Chinese medicines, including the registration of practitioners of Chinese medicine, the licensing of traders in Chinese medicines, the registration of proprietary Chinese medicines, and the manufacture, possession, and sale of Chinese medicines. No questions? Next. Next, Part 14A, about the licensing of proprietary Chinese medicines traders. We are going to add Section 138A after Section 138, which is Part 14A, Chinese Medicine Safety Order, Division 1, Preliminary, and then Section 138A, Interpretation. In this part, Chinese medicine or related product means a Chinese herbal medicine, or rather immediate product means a substance or compound that is generated in the course of manufacture of a proprietary Chinese medicine, and that is intended for use in the further preparation or production process of the medicine. We have a proposed amendment. Now, it is originally written, and that is intended for use. And we are going to change it to, that is for use. Let me read it out. The amendment is, intermediate product means a substance or compound that is generated in the course of manufacture of a proprietary Chinese medicine, and that is used in the further preparation or production process of the medicine. Legal advisor. Now, for the proposed committee stage amendment put forward by the administration, this is a response to the concern raised by the deputation. It will change back to the original meaning in the interpretation. I want to know whether the corresponding change will be made in the English version. That is, instead of intended for use, it will be to be used. Yes, we'll use the original version. Can you tell us why? Previously, our thinking is that it is intended for use, but it is not yet used. But at the hearing, according to the industry, intended for use and to be used would in fact carry the same meaning. And that is why we agree that we should change it back to be used. So that means no change is necessary. We'll just follow the original version.
Thank you. Intended to be used has a broad meaning, meaning that you just intend to use it. Shall be used is slightly different in meaning. If the government intention is that the old, it's the same as the old, version, then and it also addresses the concern of the deputation, then it's fine. All right. Any further questions? If not, let's move on. We will now come down to Chinese Medicine Safety Order, and that is the order made pursuant to Section 138. Chinese medicine or related products relate to A, a Chinese herbal medicine, B, a proprietary Chinese medicine, and C, an intermediate product. Any questions? If not, we shall continue. Division 2, Making of Chinese Medicine Safety Order 138B, Chinese Medicine Safety Order 1. The Director may, by order in writing, do either or both of the following. A, prohibit the sale of a Chinese medicine or related product. B, direct that a Chinese medicine or related product that has been sold to be recalled and specify the way in which and the period within which the recall is to be conducted. Any questions? Legal advisor. Regarding the drafting here, Section 138B empowers the director to make an order in respect of Chinese medicine. The definition of Chinese medicine relates to three categories, namely Chinese herbal medicine, proprietary Chinese medicine, or intermediate product. I think this amendment is the result of the litigation earlier, when the Director of Health issued a recall order. At the time, it did not consult the expert, and the director only suspected that the lozenges was a proprietary Chinese medicine. So under the bill, is it the case that you would still require the director to, before issuing the Chinese medicine safety order, that he should have sufficient evidence to be satisfied that the product is either A, B, or C? Dr. Choi, yes. If a Chinese medicine safety order is to be issued, the director would need to be satisfied that the product concerned is a proprietary Chinese medicine. Are you saying that the director would only need a reasonable doubt, or so that I think for that we need to go back to the definition of proprietary Chinese medicine? Dr. Choi. Well, my question was, in the previous litigation, I think the director lost the case because if you have reason to doubt, that is not sufficient. It would appear that the relevant product must satisfy or fall under the definition of A, B, and C before you can issue a Chinese medicine safety order. If the director only has a suspicion, that's not sufficient. Is that a correct understanding? Well, regarding the case law, it had to do with the question of recall. The court ruled that the director didn't have the power to order the recall, but we didn't lose the case in respect of the definition of proprietary Chinese medicine. So the definition remains unchanged. According to the ordinance, if the product satisfies the definition, fits the definition of proprietary Chinese medicine, the director can issue an order for the recall. Perhaps I can put the question in another way. When the director issued this safety order, before she does that, would she need evidence such as reports from laboratories so that she is satisfied that the product is either A, B, or C before she would issue such a safety order? Yes, the director would need evidence to satisfy him that the product concerned is a proprietary Chinese medicine. Mr. Siu Ka-fei? Thank you. I'm sorry, I have to hop between two meetings, so I may have a question which will not be directly relevant to the bill. I would like to ask a question about some, beauticians which treat, people's, and some people have been arrested. I understand that this is not on the agenda today, but that we should go to the Chinese Medical Council. But I don't think there's any representative from the trade on that council. So who is going to speak on their behalf? We were telling the chair just now that the development of traditional Chinese medicine, the professional development, I think the matter can be followed up by the Chinese Medical Council. Mr. Siu was asking about the operation of certain beautician industry, which seems to have violated the Chinese medicine ordinance. I think this question could be followed up in a different forum. I understand that some of my colleagues have already taken this up with Mr. Siu and the trade. I'm sure we can follow up on that in that forum. I understand that we have already had a meeting, but other than that meeting, I understand that the Chinese Medical Council is responsible to oversee this. But that council is not represented by people from the beautician industry. All the people sitting on the council are only traditional Chinese practitioners, medical practitioners. So, for example, for the beauticians, who may perform massage on people's pressure points and so on to improve circulation. If they did that, they might have already breached the law, and there are now prosecutions pending, so they don't know what to do. We're now talking about the Chinese Medicine Amendment Bill. I wonder whether or not this is the time we should raise the issue, because I think before Mr. Siu came, I think we should take this opportunity before we can talk about the development of the entire Chinese medical industry, because there are no other channels. Although you say that there is another committee, but apparently that committee that council is not really, performing its function effectively. So perhaps you can take the opportunity to answer Mr. Siu's question. The beautician industry is not the Chinese medical medicine industry, and that's why. Well, regarding the concern of the beauty industry, it has to do with the enforcement by the Department of Health, and whether or not the enforcement would affect would mean that the operations of the train might have breached the law. So I think the enforcement officers of the Department of Health can actually follow up on this with people from the beautician industry. So I suggest that our bureau and the Department of Health can follow up on this together with our friends from the beauty industry. Now, in the law, you stipulate that if people claim that they can, for example, provide treatment on people's circulation system and so on, they must be TCM practitioners. But when someone, provide massage services and so on, but they cannot make such a claim. But these people are now being prosecuted. We already have some prosecution this year. So I was wondering whether or not we should also address that issue while we are deliberating on this bill. Mr. Chen, I think both members and representatives from the trade have raised the same point over and over again. Could you cover both issues at the same time in one go? Of course, the TCM practitioners are professionals. We're not saying that the beauticians are trying to take away the business of the TCM practitioners. The TCM practitioners will provide treatment. The beauticians will probably offer massage services, or how should I put it? Working on people's pressure points to improve the client's health. How would you call it? It's actually health enhancement. It's not medical treatment. We're talking about health enhancement. So you're going to split them up. So on the one hand, you have, Chinese medicine service, which has to be, within the realm of the TCM practitioners. But we also have other people, for example, selling nutritional, Chinese herbal products. I think there's a lot of confusion in the market, and people in the industry are worried that they might actually, inadvertently breach the law. And the TCM practitioners are worried that the others, that they are robbing the business. I think the problem encountered by the beauty industry is outside the scope of this bill, because this time we're talking about the Chinese Medicine Safety Order. I don't think this is something which the beauty industry would be interested in. Mr. Siu is talking about a question of enforcement rather than the amendment of the law. On the question of how the Department of Health enforces the Chinese Medicine Ordinance and whether or not the behavior of some TCM practitioners, whether they're doing things which the beauty industry is doing. So I think we're already following on this, except that we're doing it through another forum. But you don't have legislation to enforce, and as a result, people may breach the law inadvertently. Now that you are reviewing the ordinance, why won't you take care of this issue at the same time? Because people are now so confused. Chairman, Madam Chair, if we were to allow non-TCM practitioners to do the work of TCM practitioners, I think we need to consult the industry extensively. Well, many people, like to have massage services. So, but that is a form of actually health promotion or health enhancement. So I don't think you've thought out all the issues clearly when you drafted the bill. But since no other colleagues have put up their hands, that's why I have not set a time limit. But now we have two, Mr. Chen Bun and Dr. Helena Wong. Shall we say each member be given 8 minutes? Thank you. The bill is about the recall of TCM products, and we are empowering the government to order such recalls. In the past, the Committee on TCM have been very concerned about the question of recall. When a certain medical product was labeled HKP, and after it has applied for HKC, we do not have any clear stipulations regarding the transitional arrangements. And this may give rise to the question for the need for recall. When someone switches from the P license to the C license, the products bearing the P label would supposedly has to be, taken back from the market. So it's sort of like a recall. So the bill would also seek to rectify the situation. Because this is not a transitional arrangement, it's actually a shortcut. Once the product is labeled C, then you can no longer find products with the label P. So would you take this opportunity to, rationalize the system? I don't know whether Mr. Chen understands my point. Dr. Chen. According to the current ordinance, registration of proprietary Chinese medicine provides for a transitional arrangement. So we now have the HKP registered products. There are about 7,000. We are, in response to the demand from the trade, we would like to convert the HKP products to formally registered HKC products. If an HKP products, if it wants to be formally registered, once it has obtained the registration number, then the transitional registration number will be cancelled, because for the people who identify the product according to its official registration number. The trade over the years have demanded that once they have obtained the registration number, they may still have some old stocks of such goods bearing the label HAP that they have not yet sold. And the council, having talked to the trade, now has agreed that after they have been granted the HKC label, they will not, receive the HAC label yet. And then they can ask for a 12-month grace period so that they can dispose of the old stock. And if 12 months are not sufficient, they can ask for another extension. So when the HAC license is granted, the trade can have a maximum of 2 years to dispose of their products with HKP transitional registration so that they will be able to sell the products under the label HKC. Products bearing the HKP and HKC labels, the difference is that the HKC products are formally registered. We would have more stringent requirements in terms of the packaging, the specifications, the instructions for the users, and so on. So the requirements for those which are under transitional registration is more lenient. That's why we want the goods which are under temporary registration to switch over to permanent registration as soon as possible.
Madam Chair, I don't think this is a transitional arrangement at all. Imagine this is the Chinese medicine, and now it is labeled HKP, certain ointment, and then once the HKC is granted, then the license will be with the Department of Health. Because he cannot get the license, because once he does, this batch of products will disappear. And it's only after the whole batch of products is gone from the market can you get a C license. So the retailer may be selling product, the products, they have completed the sale, but not the other retailer. And it takes time. That means one can only get a C license after all the retailers have sold off their stock. And they need to get a C license before they can sell another batch of products. So it's a shortcut. If you don't want it to be out of stock for so long in the market, the only solution is to opt for a recall. But if the products are recalled simply because of a licensing arrangement, and then the products recalled will be sent to the landfill, I think this is the most ridiculous part of the bill. As we talk about the director's power to recall products, we need to address this long-standing flaw in the system. It is heavily criticized by the industry, and I have time and again raised this issue with the department. It is a failure. It is a problem. Now, I don't know whether my understanding is correct. After getting the C license, they can no longer make available P products in the market. So there is a transition here. You cannot have C and P products available for sale by retailers at the same time. You may allow a 6-month or 12-month transition, and that will do. Because in actual fact, the ingredients of the medicines are entirely the same. The only problem is that during the transitional period, they have two different labels, HKP and HKC. As long as we extend the HKP for a little while, that means after getting the C license, you will be allowed 6 months or so to phase out the old batch of goods in the market. Then that will do. I would find this reasonable. But now you have a sharp cut approach. I find this problematic. I wonder if Dr. Choi would consider it. Because according to the industry, they don't think that this arrangement has addressed their issue. And I think that we'll be missing this opportunity to do so if we just leave it here. At the last public hearing, some practitioners told us their view on the whole Chinese medicine ordinance. But on the point of recall, we haven't really consulted the practitioners. So, Madam Chair, I think we should allow them an opportunity to speak on the recall order, and I ask for a public hearing. Any response from Dr. Choi? Now, as I mentioned, when HKC is granted, there won't be HKP products available in the market. To address the needs of the market after formal registration is granted, that is in HKC, there will be a 2-year period for the industry to sell off all the stock in the market. Of course, they need to consider how to sell off the HKP to be replaced by HKC products. At the same time, we need to address the public's concerns. If at the same time, for the same product, you have the provisional packaging and the formal packaging carrying two different labels, it would be confusing for the public. We have struck a balance between the public's concerns and the industry's concerns. Just to supplement, Madam Chair, I think you know where I'm coming from. This is a sharp cut. This is not a transitional arrangement. This is a fake transitional arrangement, and this is very much the grievance of the industry. So we can discuss whether to hold another public hearing in due course. Dr. Helena Wong, followed by Mr. Peter Shiu. Madam Chair, I have a question on the applicable scope of the recall order, and that is PCM, CHM, and intermediary products. Now we have herbal tea shops selling, different products for treating flu and other matters. Should they be regarded as intermediary products, PCM or CHM? Is it under the regulatory scope? It's Chinese herbal medicines. Was it actually in the schedule? Herbal Chinese medicine. These are dried Chinese medicine. As for PCM, we have a definition in the law regarding proprietary Chinese medicine. For intermediary products, in the preparation of proprietary Chinese medicine, there might be intermediary products in the form of powder or liquid, and these are the intermediary products manufactured by the manufacturers for the preparation of proprietary Chinese medicines. I was asking about herbal tea. Is it regarded as a CHM or what? Well, herbal tea is rather generic term, because let's say for different types of herbal teas, they may contain a number of different CHMs. They may have different names for the herbal teas, and we are referring to Schedule 1 and Schedule 2 of the CMO, which contains 605 CHMs. So if one or more than one type of CHMs in the schedule are used, it falls within the scope of the regulation of the ordinance. Right. We can then move on to talk about the recall order. Let's say in the schedule we have a kind of herb which is found to cause harm to human health. Then with empirical data, the director may order a recall of this kind of herb. So for this Chinese herbal medicine, we're referring to those set out in the schedule. Well, there may be several hundred kinds of Chinese herbal medicines. I'm just asking for the herbal teas sold at herbal tea shops. They may have different ingredients comprising different Chinese herbal medicines. You just tell me yes or no whether it's regarded as CHM, or would you take samples from CHMs, from herbal teas and check for heavy metal content or pesticide residues? I just want to know whether they fall within the scope of the bill. Now, if Dr. Wong is referring to herbal tea that comes in liquid form in herbal tea shop, to be readily consumed, then first of all, it is not a CHM, it is not a PCM, it is not an intermediary product either. So it is not caught under this bill. And if you're referring to the kind of herbal tea or soup that is sold in herbal tea shops, you're being inconsistent. How about the common herbal teas prepared for sale in these shops? They're made from CHMs. That means you regulated the ingredients, the CHMs, for preparing herbal teas, but not the herbal teas themselves. Now, for Chinese herbal medicines under this bill, we're referring to dried medicines and also PCMs. These are products, packaged ones. As for the herbal teas prepared in the manner described by Dr. Wong, is not under this bill. But of course, you may have 5 types of CHMs for the preparation of the herbal tea, and these 5 Chinese herbal medicines will be caught under the bill. I don't understand, Madam Chair. It seems to be a loophole here, because you have different kinds of herbal teas for treating heat in the body, for treating flu, etc. So you're not regulating these herbal teas. You're regulating the Chinese herbal medicines. When we ask about whether there is any regulation on the heavy metal content or pesticide residues, then after the teas are prepared, well, it's really confusing. What if after the herbal teas are prepared, they are then packaged and comes in powder form? Then would you regulate those as well? Well, I can just put all the ingredients in, and then I just cook them and prepare them. If you regulate the CHMs only, I can just prepare them and then just cook them, and then you won't be able to regulate the products. Let me explain that for the ordinance, what we are targeting is CHMs as for sale So that means dried herbs sold at Chinese medicine shops. For the other kind, it's proprietary Chinese medicine that comes in the form of powder, liquid, etc., or other kinds of preparations. As for the herbal tea sold by herbal tea shops, this is under the purview of the FEHD, and they are required to obtain the relevant herbal teas license. So for the herbal teas readily to be consumed, and this is under the purview of the FEHD. Are you sure for the Center for Food Safety, they would check these herbal teas as they come in the form of food? The chicken beets herbal tea, I can confirm that they need a license to sell herbal teas. So do they take samples of herbal teas for testing? Can you confirm with the Center for Food Safety whether anyone is overseeing this? I have nothing to add on that operations. Mr. Chan, anything to add? Perhaps after the meeting we can ask the FEHD on the enforcement of in relation to herbal tea shops. I can supplement this information after the meeting, but I understand that for Chinese herbal tea medicine shop, and I stand to be corrected, they procure Chinese herbs for the preparation of herbal teas. And as I understand, they need to procure the materials from licensed CHM suppliers. So when the director issues a recall order, the wholesaler, the supplier would need to recall these products in question. I'd like the administration to further clarify this point. We have Chinese medicine shops preparing Chinese herbal medicines for the clients, as well as cooking the medicines for them. So under this bill, these herbs can be confiscated if there is a recall order. What if they are cooked? Are you going to check the product itself, the tea itself, or the ingredients, or will you just check the CHMs? For Chinese medicine practitioners, a license is required, and then the Chinese medicine practitioner can issue prescriptions for patients to obtain CHMs from licensed CHM shops. And in these shops, some of them do help prepare the medicine. And we have come across these incidents of high toxicity, and the preparation may be toxic, and we do follow up on these cases. As for recall order, we are looking at things on a larger scale, and that is wholesale, at the level of wholesale. So in the event of contamination or any problems arising, we will trace back to the supply level. For a Chinese medicine shop preparing the medicine, it is not going to have widespread impact. Of course, if there is any problem arising from the preparation in the Chinese medicine shop affecting the public's health, in terms of the licensing of this shop, will take follow-up action.
Mr. Siu-Ka-Fai. Thank you. First of all, I don't quite agree with Mr. Chan's point about the discussion regarding Chinese herbal medicine, because there is no forum for them to have a direct dialogue on this in detail. Of course, they've met with the trade, they have had one meeting lasting an hour or two, but how can we have a discussion, about the ordinance? I think there's a problem. So how can we let the industry know what is happening? Mr. Chen Hangban also talked about the question of KVG. I think it might be necessary for us to hold another public hearing Otherwise, that issue will be delayed for yet further. And secondly, to follow up on Dr. Helena Wong's point about the Chinese medicine ingredients, Chinese medical ingredients, and the administration told us about the procedure. In the wholesale and retail industry, they are very concerned that if you were to test the Chinese herbal medicine, because most of them are plants grown in different provinces in China, because of the differences in soil condition, the quality may vary. Traditionally, with these herbal medicine, when they are arrive in Hong Kong, they are used to make herbal tea for the patients to drink. And I understand that the herbal products, after they've been heated, after it has been subject to heat, the quality may change. The original ingredients may contain certain pesticide residues or chemicals. Actually, all products carry these chemicals and pesticides. But after it's being treated with high temperature, then of course these residues and chemicals may the content will be reduced, because after boiling, the quality or the nature of the product will change. So if you're going to test those products as well, the whole market will become very confused. So I'd like to ask Mr. Choi about this issue, which the industry is very concerned about. I think the industry is also understand that the intention of our conducting tests is to ensure that Chinese herbal medicines sold in the market are safe for the public to use. The standard according to which we conduct our tests, the industry is familiar about the 4 heavy metals and pesticide residues. If any problems are identified, I think the industry understands that every time they will cooperate us whenever a recall is necessary. As to whether or not we should further enhance the standard for testing and so on, we certainly monitor the international situation, and also whether there will be new items which will be required to be tested according to the Chinese medical arrangements or regulations. Dr. Wong had expressed her concern, which I understand. And I think there's some point in what she's saying. If the ingredients contain a lot of, pesticides or chemicals, it may adversely affect the health of the patient. And I think such concerns are justified. But for the whole process, that is how the Chinese herbal medicine arrive in Hong Kong, and then they are sold to the retailer, and then the customers will buy them and boil them. As a doctor, do you understand this whole process? Could you tell us, more specifically this? When these different Chinese herbal products arrived in Hong Kong, and before they sold to the customers, would you take any, random samples for testing? And when they're being sold to the customer, take, for example, the chrysanthemum tea, for example, how do you test them? And also, how many times would you conduct such tests? Let me explain to you the surveillance system we have in the market. The rationale behind the surveillance system is that we would like to conduct some surveillance together with the industry to ensure that the quality of the Chinese medical products sold in the market. Relying on lab testing will not help too much. The important thing is to ensure that the trade would buy herbal products of suitable quality. the licensing conditions for the industry is such that, and the industry would know that the herbal products that they buy have to be procured through legal channels and and the quality should be up to standard. And they will also need to retain the invoices so that when you need to conduct a record, they can trace all the herbal products and identify where they have been sold to. For market surveillance, first of all, we do it at the retail level. We will buy some herbal products for testing. And starting from February, we'll also buy these herbal products from the wholesalers for testing. When the problem occurs, in the past, we had situation where there have been confusion over different categories of herbal medicine, and a recall was necessary. In those circumstances, the wholesalers did really cooperate with us very well because we have a very good, system to trace the origin of the products. So that's what we do regarding the surveillance of the Chinese herbal medicine sold in the market. There had also been cases of poisoning. That is, when a member public buys certain Chinese medical products in the market, they boil them at home and something goes wrong. And after we've been notified by the HA, if we discover that one member public has become ill after taking using such medicine, then we will find out the cause of his illness. We may suspect that it might be a case of overdosage or improper labeling of the herbal products. We will then go to the retailer concerned to find out whether the labeling of the product is correct. If there are any problems, then we'll follow up according to the current mechanism. And we may impose disciplinary sanctions. And we also try to find out whether it is due to systemic issues and that the problem occur actually at the wholesale level. So this is how we deal with situation where member public are adversely affected. So regarding the first method, you will take samples in the market for testing. When you did that in the past, what sort of standard do you follow? Do you follow the WHO standard, or would there be different standards for different herbal products? And for these standards, before the herbal products are boiled and not boiled, and after they have been boiled, do you have separate standards for them? Well, the Chinese Medicine Committee Council set the standard in 2011, and they will encompass all the 605 herbal products. We're talking about 4 heavy metals and 37 pesticide residues. So this is a standard which applies for traditional Chinese herb medicine in liquid form. This is different from the international standard. In 2001, when we set our standard, there were no common standard yet. The standard that we are now adopting is basically focused on safety. And the industry also understands, because we've announced to the trade on our website that we are focusing on standards for the 4 heavy metals and the 30-odd, pesticide residues. And so far, we found that the situation is satisfactory. Every month, we will take about 45 samples of Chinese herbal medicine for testing. We hope that in a year, we'll be able to take samples of all the commonly used herbal medicine in Hong Kong for testing. Should there be any medical products which we discover contain a high level of heavy metals, but they have not exceeded the standard, then perhaps next year we will step up the testing. Well, do you have a number, that is, of the number of samples that you've taken and found, and those which are found to be problematic? What is the percentage, roughly, of the 100 tests that you've conducted? How many would turn out to be problematic? Any, Dr. Choi? I think at previous meetings we've already disclosed those numbers in one of the papers. In the past few years, of all the TCM samples that we've tested, none of them have exceeded the compliance standard. They've all met the standard, yes. We talk about 2 stages, the ingredients and then the Chinese medicine in liquid form. 2 other members have already put up their hands. Mr. Chen Ban and Mr. Xiu Ka-fen have suggested that we should conduct another public hearing. I'd like to consult with members whether you would agree that we do that. So what exactly do we want to talk about at that public hearing? We already have one public hearing already. If what we're going to consult at the public hearing has nothing to do with this bill, then I would not agree. Perhaps we can find a more suitable forum to conduct such a public hearing. Mr. Juns Ho. Madam Chair, I remember last time I also asked Dr. Choi the same question. For the TCM medicine which is boiled into liquid form, would they be covered by this bill? The answer was no. I understand. No. I think let's deal with the public hearing first. So in that case, I think I am quite confident. But having heard the discussion today, I think for the people who operate the herbal tea shops, they may have concern. They may ask whether they would also be caught if they use the herbal medicine products in the annex. So in that case, I think we should. There's nothing wrong for us to consult the industry. There's no harm to conduct another public hearing. Certainly, there's no harm in doing that. Other members. I also think that we should listen to more views from the industry. Since I represent the industry, and I know that many of them don't understand the issue, and some of them are worried now that they might be arrested if they breach the law. Mr. Kwok Wai Keung. Thank you. Mr. Siu Ka-fai, I think Mr. Siu Ka-fai's suggestion should be considered. Dr. Helena Wong said that we shouldn't repeat the same questions at this public hearing. But if we, define if we stipulate that for this public hearing, we're not going to talk about issues we already discussed the last time, then I think it's right. It's the right thing to do. Because we're talking about empowering the director to perform his duties. So, Chairman, I'm confused. I don't know what exactly we want to hear if we were to conduct this public hearing. Are we inviting people to submit views on the bill, or are we going to talk about the operations of the herbal tea shops? And Mr. Chair is talking about, massage and nutrition. That doesn't seem to be under the purview of this ordinance or this bill.
Now, if we are to hold another public hearing, we will send invitations through the Secretariat, who will no doubt remind the deputations that they should speak on this bill. So if we hold another public hearing, we'll be inviting deputations to speak on the bill. But like Mr. Ben Chan said, as I understand, at the previous public hearing, we didn't hear a lot of deputations speaking on the bill itself. So he would like to have another public hearing so that deputations could speak on the recall order, which is the crux of this amendment. I think that we need to have more meetings anyway, and perhaps at the next meeting we can allocate some time for the deputations to express their views specifically on the recall order. In fact, after the last public hearing, some deputations also approached me expressing concerns about this recall order. We're not going to have the whole meeting dedicated to a public hearing, but we can allocate some time at the next meeting for members of the public to express their views on the recall order. All right, then that's that. 2 members would like to speak, Mr. Kwok Wai Keung, followed by Dr. Junice Ho. I'm not a professional. I'm not a professional of the retail industry or the Chinese medicines industry. I'm just an ordinary user. And for a mother may prepare soup using Chinese herbal medicine, or if you go to a Chinese restaurant, they might also use Chinese herbal medicine to prepare soup as well. So whether the ingredients are harmful to human health, etc., there are different ways to handle the matter, such as, for example, the herb called chicken beets. For the Chinese medical practitioner, he would say that if you cook longer, the toxicity would be different. And there are also some ingredients that must be combined with others in order to have any effect. So when the director issues a recall order, what will he consider? Will he seek professional advice? And what if it is later discovered that it has nothing to do with the CHM themselves, but how the decoction is done? How would it be dealt with? Dr. Choi. The objective of the recall order is that when there is a systemic problem with the CHM, for example, the quality of a batch of CHM is in question, or that the toxicity exceeds the normal level for that kind of CHM, then this systemic problem would affect the public. Public health will be affected, even if the chain of sale and preparation is done properly. And that is why a recall order is needed to recall products at the point of sale. Now, the honourable member mentioned the decoction of CHM for a long period of time for the medicine to have any effect. Then that a member of the public might have decocted the CHM for the shorter than the time required. In such circumstances, we will not ask for a recall order. We're talking about things at the systemic level. That is, we must recall the whole batch of CHMs to minimize the public health risks. We understand the spirit of the bill, and that is there is a systemic error, and something needs to be done. But how do you know the toxicity in CHM itself, whether the toxicity appears later because of how it is handled, because of any additional ingredients? Would you seek the expert advice of a Chinese medical practitioners first? And when will you take action? This is a professional judgment. First of all, whether we have literature or empirical data to back the director's decision to recall a batch of CHM because of a public health incident. An example is this. For CHM, when it is, say, for a kind of CHM, if it is raw, it cannot be consumed. It must be cooked first. And if in the process of manufacturing there is a wrong labeling, making the kind of CHM as cooked when it is actually raw, then we have the scientific evidence that it would have high toxicity. And in that case, the director will make a decision to recall the whole batch of CHM. And in the Department of Health, we also have a whole team of professionals, Chinese medical practitioners, as well as pharmacists providing support. So the director definitely would consult the DH first the Department of Health first. It's not included in the bill. However, it only provides that where there is a problem, the director may take this action. There is nothing explicit about consulting the team in the Department of Health. The Director of Health is the head of the department, and he is supported by professionals in the department. And apart from that, we need objective scientific data, for example, testing results to confirm that these CHMs have problems. So you need to go through a series of procedures before you issue the order. The question is, how long does it take to go through the procedures? It depends. Say, if in the example I mentioned, it is raw, but it is label processed, then we will ask the laboratory to conduct a test for us to verify or to ascertain the issue. And the test can be swiftly done. And once it is done, since this case doesn't take a long time, we can make a very swift decision. So it's on a case-by-case basis, but like the example I mentioned, it should be recalled as soon as possible. So you cannot tell us an exact time frame, like 1, 2, or 3 days or a week. We're all concerned whether the government is taking up the matter full steam. If we have an objective time frame, we would be better able to reassure the public. But like you said, it depends. The Department of Health conducts assessments on a risk-based approach. Any action taken will be based on the level of risks. The director will not immediately issue a recall order. Usually, the director would urge the practitioners to recall on a voluntary basis the products. And I think that the traders concerned would voluntarily comply in the first place. And for products that do not entail a high level of risk, sufficient time would be given for the traders to recall the products, and the timetable would be, the time frame would be reasonable. It is, on the contrary, unreasonable to stipulate a time frame in the law. On the other hand, the director or the Department of Health would make a professional judgment, whilst at the same time liaise with the licensed traders. But like I said, for products with high toxicity, there is no room for negotiation. It should be carried out as soon as possible. If there are no other questions from members, we can resume the class-by-class scrutiny. Let's move on. Division 2138B, bracket 2. The grounds on which a Chinese medicine safety order may be made are set out in sections 138C and 138D.
Okay, that no.
Okay. 138C, grounds for prohibiting sale. The director may make an order under section 138B, bracket 1, bracket A, only if the director has reasonable grounds to believe that A, for Chinese herbal medicine, 1, the medicine has been sold or distributed in contravention of section 109, bracket 2, or 111, bracket 2. Any questions? Please continue. Legal advisor. Thank you, Madam Chair. Perhaps we can elaborate on section 109 and 111, please. 109, bracket 2 means unlicensed wholesaling of CHMs in Schedule 2. 111 means unlicensed wholesaling of CHMs in Schedule 2. And that is if an unlicensed wholesaler cells, CHMs, in Schedules 1 and 2, then there is ground for the director to believe that there is a danger. So no testing is needed as long as the seller is unlicensed. 2. The medicine is dangerous or injurious to health or unfit for use by human beings. Or, please continue. 3. The order is necessary to prevent or reduce the possibility of danger to public health or to mitigate any adverse consequence of a danger to public health. No questions? Please continue. B. For proprietary Chinese medicine, 1. The medicine has been sold in contravention of Section 119, bracket 1, 143, or 144. Legal advisor. Right, let me explain. 119, bracket 1, sale of unlicensed PCM. 143, sale of sale of PCM without the prescribed labeling. 144, sale of PCMs without the prescribed manual. 2. The medicine has been sold or distributed in contravention of Section 134. Section 134, unlicensed wholesaling of PCM. 3. The medicine has been manufactured in contravention of Section 131. Section 131, unlicensed manufacturing of PCM. 4. The medicine is dangerous or injurious to health or unfit for use by human beings. Or 5. The order is necessary to prevent or reduce a possibility of danger to public health or to mitigate any adverse consequence of a danger to public health. And please continue. C. For an immediate product, 1. The product is dangerous or injurious to health or unfit for use by human beings. Or 2. The order is necessary to prevent or reduce a possibility of danger to public health or to mitigate any adverse consequence of a danger to public health. Legal advisor. Madam Chair, I note that one of the grounds for recall is that the product is unfit for use by human beings. In the original first version, it is unfit for consumption by human beings. Can you explain that, Dr. Choi? Because the word use includes oral use and external use, so the scope of the word use is wider than before. It also covers preparations for external use.
Please go on. 138D, grounds for directing recall. The director may make an order under Section 13AB, bracket 1B, only if the director has reasonable grounds to believe that A. For a Chinese herbal medicine, the medicine has been sold or dispensed in contravention of Section 109, bracket 1 and 111, bracket 1. Please go on. 109.1 is about illegal wholesaling. 109.1 is retailing traditional Chinese medicine without a license in Schedule 1. 111 is dispensing traditional Chinese medicine without a license. 2. The medicine has been sold or distributed in contravention of Section 109, bracket 2 and 111, bracket 2. 109, bracket 2 is about illegal wholesaling of Schedule 1 Chinese medical products. 112, wholesaling without a license, the Schedule 2 Chinese medical products. 3. Medicine is dangerous and injurious to health or unfit for use by human beings. And 4. The order is necessary to prevent or reduce a possibility of danger to public health or to mitigate any adverse consequences of a danger to public health. All right, go on. B, for proprietary Chinese medicine, the director has reason to believe that the medicine has been sold in contravention of Section 119, bracket 1, 143, and 144. 119, bracket 1, selling PCM without registration. 143, selling PCM without labels. Probably 144, selling PCM without proper, instructions or manuals. I think this is related to the question raised by Mr. Chen Hangban. No, Mr. Chen was talking about HAP and HKC. HAP products are allowed to be sold in the market. Once the HKC license is issued, then the HAP would be void. So does that come under 143? Dr. Che. Perhaps I can defer to my colleague, Dr. Yong. If the product were an HKP product, according to the Chinese Medicine Ordinance, when an HKC is issued, the HKP would become void automatically. So the HKC label, only the HKC label will satisfy 143. 143 is about the labeling of PCM. So the registration would have been updated when the HKC license issue. When the applicant can choose to have a maximum of 2 years to dispose of all the products with HAP labels. These HAP products with HAP products also satisfy the requirements under 143. The seller would only want to convert the products from HAP to HAC after 2 years. And starting from after 2 years, then they will need to satisfy the labeling requirements under 143. When it's switched over to HAC, 2 years. 2 years after that, if they still sell product with HAP, they're still not in breach. Now, when it is granted an HAP label, the committee will ask him when the applicant would like to apply for an HKC label. So that is when they will label their products HKC and not HKP. If they choose for 2 years, then from the time of approval and all the HAP label products then they would still be allowed. But since the seller has chosen for 2 years, of course you remind him of the deadline, and he will need to plan ahead. That is, before the expiry of the 2 years, he should have already disposed of all the stockpile, the stocks, and then he can then launch his products with the HKC label. With the commencement of the HKC label, that is, the seller has chosen to use the HKC label. If he still sells products with the HKP label, would you then punish them? Would you still invoke a recall order according to 119 or 143? Would you still be, invoking a recall order or issuing a recall order? If the product has already been granted the HKC label, and when the so it is no longer a PCM. But the Permanent Secretary also said that in order to carry the recall, other than the recall order, we need the cooperation of the industry. The switch from HKP to HKC. Many people in the trade, they would withdraw the products after they have been granted the HKC label. And we have never been required to ask the trade to recall. the industry all along has recalled their own product with HKP label in order to get the HKC label. And in future, even after we've issued the recall order, we will still communicate with the industry, so that if we have no other option but to, we only issue the safety recall order if we think the public health is at risk. You say that you're already doing this and you continue to do this. You rely on the cooperation. That is after the a seller has been issued HKC label, they will recall all the HAP products. But if they don't, can you through the amended ordinance invoke or issue the recall order instructing this seller to recall the HKP products? Yes. I think this is what we want to clarify. And that's why Mr. Chang Beng particularly raises this point, because this is the concern of the industry. So you're now saying that you're relying on, a dialogue with the industry, and before the expiry of the deadline, you ask them, remind them to, withdraw all the products with HAP products. But if they continue to sell those products, then you can, issue a recall order and demand that they recall these products with HAP labels. Okay. Yes, please carry on. 134B2. The medicine has been sold or distributed in contravention of Section 134. 134 is wholesaling PCM without a license. Right. 3. The medicine has been manufactured in contravention of Section 131. 131 is illegal manufacturing of PCM. 4. The medicine is dangerous or injurious to health or unfit for use by human beings. Or 5. The order is necessary to prevent or reduce a possibility of danger to public health or to mitigate any adverse consequence of a danger to public health. And go on. C. For an intermediate product. The product is dangerous or injurious to health or unfit for use by human beings, or the order is necessary to prevent or reduce the possibility of danger to public health or to mitigate any adverse consequence of a danger to public health. Thank you. Legal advisor. What is the difference between 1 and 2, Dr. Che? Are you talking about dangerous or injurious to health? Perhaps I can give an example. Injurious to health would be more serious. One example would be what I told members just now. That is, the raw Fuji is labeled as processed Fuji, and this is what we're worried about, because if you administer with a raw Fuji, it could be highly toxic and injurious to health. Injurious to health, one example would be a herb called Fuji, which needs to be processed before the toxicity is reduced. If it's not processed properly, then for these Fuji, we are not it may have different levels of toxicity, and then we may have to recall it because it may be dangerous to health. And C3 would be, in some cases, we've found that for some of these Chinese herbal medicine, the industrial dye has been used, but so we're not sure about the impact on human health. But this is an example showing that it's unfit for human use. Another example is to prevent or reduce the possibility of danger to public health. In other words, there is a possibility of prejudicing public health, and we would like to minimize that risk. For example, you may have TCM products which in liquid form, I think in this packet, the dosage is, prescribed, but the prescribed dosage is exaggerated. For some patients, they may not suitable for them to take such a large dosage, and the wrongly labeled package may actually be dangerous to public health, and that's why we will record the products to minimize or to reduce the risk, or to mitigate any adverse consequence of a danger to public health, and this is more indirect. One example would be that for some Chinese herbal medicine, its ingredients may contain asbestos. If it is not properly stored, the asbestos may evaporate in the air, and some staff or members public may breathe in the asbestos, and it will be, injurious to the health. So we're not talking about direct consumption here, but rather the indirect impact that the medicine causes. For PCM and Chinese herbal medicine, there are other ordinances governing the legal manufacture or sale of these products. But what about intermediate products? There are no such, similar ordinances. You're just relying on the record order. If you find that there are problems, then you would record them. For intermediate products, since it is not defined as PCM or Chinese herbal medicine, but we understand from the industry that certain manufacturers of Chinese herbal medicine may manufacture intermediate, products which will be sold to other manufacturers. In this case, the impact could be significant. If there's something wrong with the intermediate products and they are sold, these products are sold to many parties, those who buy the intermediate products and make the finished goods may also be affected. And that's why we would need a record order. So we don't have legislation to regulate these intermediate products. It's because you don't think that they are traditional Chinese medicine. It's not defined as PCM. PCM are products which the public can purchase directly, and it's not, TCM, traditional Chinese medicine. It's not in dry form. But in the whole process of the manufacturing of PCM, they are used. So this is where we would like to put in some controls so that if there's anything wrong, they could be recalled. Could you give an example as to what exactly this is all about? One example would be a manufacturer of a PCM, and he would need to buy certain Chinese herbal medicines as ingredients, and he would need to extract the chemical elements from these herbal ingredients, and these extracts are now used to make the PCMs. During the extraction process, the product may be polluted, and some of the toxic materials are extracted. If we discover that the intermediate products have been contaminated and these contaminated products have been supplied to other manufacturers to make PCMs, then we would require this PCM manufacturer to record the intermediate products which it has made, manufactured itself. Under Cap 549, Chinese Medicine Ordinance, there is also a part regarding the regulation of intermediate products. How are they regulated?
Mr. Yong, thank you. Under Cap 549F, the Chinese medicine regulation regarding the responsibility of manufacturers and traders, they are clearly stipulated. About manufacturer, because the manufacturer would procure CHMs, process the CHMs, turn them into preparations in the form of, a capsule, and it covers regulation of the PCM manufacturer throughout the manufacturing process. From procurement, for example, they would be required to keep records of procurement and also records of manufacturing, and also from intermediary products to the PCM, record keeping is required. According to the regulation, they are allowed to keep the control in stock such that in the event of a public health incident, the department or the government can test the control, and that's roughly the regulation on PCMs. Now, according to the ordinance about CHM and PCM, there are relevant provisions regulating them. And that is why it says here, in the event of a breach, the director can issue a recall order. But on the face of it, it seems that this doesn't cover intermediary products. Even Mr. Yong, you just referred to the situation, is not specific regulation like 119 bracket 1. And is that the case, that you cannot explicitly include this in the bill? Let me supplement. For intermediary product, it is not available in the market for purchase by ordinary consumers. We refer to CHMs and PCMs, which are available in the market but not intermediary products. It only appears in the manufacturing process in a factory. Right, but that is Mr. Kwok Wai Kwang's question. How long does it take for you to issue a recall order? If a CHM or PCM is subject to the relevant provisions, say a license is required, and you just said that a recall order will be issued without going through tests, what if for intermediary products a test would be necessary before a recall order is issued? Dr. Choi. Well, I can envisage that if there's something wrong with the intermediary products, it may refer to the unexpected toxicity of the intermediary product undermining public health, and therefore testing will be necessary to ascertain that. So for recall order targeting intermediary products, we can envisage what Mr. Kwok Wai Kwang said. It may take, say, a number of days before the Directive Health issues a recall order. Is that right, Dr. Choi? It may take time because for us to discover that there's something wrong with the intermediary product, there may be a number of possibilities. For example, a report might be made to the Director of Health because of something going wrong in the manufacturing process. The product is contaminated, and then we may need to conduct tests. The other possibility is that for the PCM testing, if any irregularity is found, we can then trace back along the manufacturing chain, then find out that it is the intermediary product that is problematic. Still, it takes time. So by that time, all the intermediary products would have been used up because the intermediary products are prepared for further processing. So by the time you discover there is something wrong with the PCM, the intermediary products would be all used up. Well, even if we're talking about intermediary products because they would be further processed into PCMs for sale, so for upstream, downstream, as long as we keep all the records, well, unless it has already been distributed to consumers at the point of sale, we can still trace it back. We can still recall all the products, PCMs, intermediary products along the chain. I just want to point out that perhaps more regulation is necessary. Maybe all intermediary products have been used up and there is nothing left but records. You have control for the CHM and PCM, and you have only this provision targeting intermediary products under which you can take enforcement action. You need to think about it. If something goes wrong, apart from the recall order, there is nothing else you can rely on in your enforcement action. Dr. Choi, if the intermediary products has been processed and turned into the PCM, what we target is that, first of all, the PCM itself will be problematic and the manufacturer or wholesaler will need to recall the products. for intermediary products, whoever is in possession of the intermediary products should not use them for further processing. So we're going to recall PCMs as well as intermediary products. Still, I hope that Mr. Chan, you will look into this issue in the long term. We'll consider whether the existing regulatory provisions are sufficient. Legal advisor, let me supplement. For CAP 549F, the regulation, section 16, refers to some general responsibilities of licensed traders. And in paragraph G, it says that there should be sufficient space, facilities for the storage of products. And when storing intermediary products, the facilities for storage should be kept in good condition. So Madam Chair's concern may be that if G is breached such that the products are hazardous to human health, why can't we make it clear that if the trader breaches these two paragraphs, he will be liable? Or would you say that just stipulating C1 would be sufficient? Who would take the question? Dr. Choi or Mr. Chan? For C1 and 2, they have taken into account the possibilities of having problematic intermediary products. It may be hazardous or injurious to human health or unfit for use. And it's also a problem along the manufacturing chain, and it is covered. But the problem is the problem is it's more expeditious because no testing is required if you put it more explicitly. Otherwise, you need to test to make sure that it is dangerous or injurious to human health. Comparing to other breaches that we mentioned, for example, manufacturing, wholesaling of the PCMs without license, we can just investigate, and with the information we can establish the case. However, for these conditions without sufficient room or facilities for storing the intermediary products, in terms of prosecution, we need to let the industry understand the grounds for making this recall order. Apart from understanding the grounds of issuing a recall order, we should understand that it leads to consequence. So from C and 1 here, it already states the grounds of issuing a recall order for intermediary products. Poor ventilation, improper storage, they will be breaching these licensing conditions. And the Director of Health can already introduce disciplinary sanction. As to whether this batch of intermediary products would pose a hazard to human health, there may not be a direct link. All in all, we already have regulations, and this can be dealt with by way of disciplinary action if there is a breach. All right, if there is a contravention of CAP 594, you can penalize them. But the point is this: the safety order should not be issued simply because there is a contravention. It's for the director to make this decision. But if you expressly make this provision, wouldn't it be more efficient and effective? We need to strike a balance. The objective of issuing a safety order or recall order by the director is because the director has grounds to believe that these products may be dangerous to human health or injurious to human health. We need to strike a balance. If all the conditions stipulated in the regulations can be grounds for the director to make a recall order, I imagine that there will be repercussions in the industry. For matters such as improper storage, poor ventilation, these can be dealt with in other ways. Mr. Chen, could you give us a written reply in relation to regulations applicable to intermediary products, and what is your consideration? Is there sufficient regulation of intermediary products? Please give us a reply. 138E, form of Chinese medicine safety order. A Chinese medicine safety order must be in this specified form and state the following. A. The person or persons intended to be bound by the order. B. The particulars of the Chinese medicine or related product that is the subject of the order. C. The reason for making the order. D. The prohibition or action required under the order. E. For an order made under Section 138B(1)(b), the period within which the recall is to be conducted. Legal advisor. I think I need to supplement. I asked about 138E point D. The prohibition or action required under the order. And according to the administration's reply, it covers the method, how this is done. Because, let's say for variation order, it prescribed in detail how this is done. Perhaps the administration can confirm this. For 138E.D, the prohibition or action required under the order, it covers our various requests. I have a simple question. A. The person or persons intended to be bound by the order. What if it's a corporation? Would you issue the order against the person in charge of that company or just the company? Perhaps my colleague can take your question. Mr. Yang. This will be in principle with our position on legal entity. Usually a company is set up as a sole proprietor or joint partnership or in the form of a limited company. For sole proprietorship or partnership, it will be issued against the persons responsible for a limited company. It will be issued against the limited company, the name of the limited company. But in fact, towards the end of the bill, when we talked about serving of notice or the serving of the order, the safety order, for limited companies, then it should be delivered to the senior person of a body corporate. Legal advisor. According to Cap 1, person includes body corporate. So apart from an individual, it covers a body corporate.
Please go on. F. The provision under which the order is made, and G. The consequences of failing or refusing to comply with the requirement of the order. Carry on. 138F. Person bound by Chinese medicine safety order. 1. A Chinese medicine order safety order A may be addressed to a particular person or particular persons, and B must be served on each person to whom it is addressed. 2. A Chinese medicine safety order is binding on a person to whom it is addressed only from the time it is served on the person. Any questions? Please go on. Division 3. Variation or revocation of Chinese medicine safety order. 138G. Interpretation of Division 3. In this division, a reference to a Chinese medicine safety order includes a Chinese medicine safety order that is varied under 138H, bracket 1. 138H. Variation of Chinese medicine safety order. 1. The director may, by order in writing, vary a Chinese medicine safety order. 2. An order made under subsection 1, variation order, must be in the specified form and state the following. A. The person or persons to whom the variation order is addressed. B. The order number of the Chinese medicine safety order to which the variation order relates. C. The reason for making the variation order. And D. The details of the variation. E. The provision under which the variation order is made. And F. The consequences of failing or refusing to comply with the requirement of the Chinese medicine safety order. Go on. 3. A variation order must be addressed to and served on each person bound by the Chinese medicine safety order. 4. Variation order is binding on a person to whom it is addressed only from the time it is served on the person. Please go on. 138I. Revocation of Chinese medicine safety order. 1. The director may by order in writing revoke a Chinese medicine safety order. And 2. An order made under subsection 1, bracket revocation order, must be in the specified form and state the following. A. Person or persons to whom the revocation order is addressed. B. The order number of the Chinese medicine safety order to which the revocation order relates. C. The reason for making the revocation order. And D. The provision on which the revocation order is made. 3. A revocation order must be addressed to and served on each person bound by the Chinese medicine safety order. And 4. A revocation order has effect on a person to whom it is addressed only from the time it is served on the person. I would like to stop here because it's almost time, because we still have the next meeting. Shall we stop here before we go to Division 4? So we'll begin from Division 4 at our next meeting. And the administration can also provide answers to the questions we asked just now. We'll set the date for our next meeting after our meeting today. Thank you very much.